Good morning. We are on the record in the matter of People versus Latavis, Trishad Thornton. This is case 25-0203.
Melissa's fault.
May I have appearances for the record?
And it's
please?
delicious.
George, thank you, Andrew. George, in the behalf of the people.
Thank you. And Mr. Thornton, could you state your name for the record, please?
I am Shoulders in here by way of Executive Office for Latavius Trishad Thornton nonprofit organization.
Accept that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school and passed the bar and been admitted to practice.
You got this. Don't worry about
So
it.
the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavius Trishad Thornton. Once again, on the record, it has not been declined that Latavius Trishad Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and a sound
so I'm
mind.
going to cut this off. I don't want to mute you, but we have to move forward. So we have an attorney standing by. That would be Mr. Foreman, who is a very, very good public
I, the man speaking with a voice, for the win.
defender who is available to you. At this point, Mr. Anid, this is the time and date set for a pre-exam conference. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should. I have a concern for his competency, to be honest with you. If of course we had the same issue this time.
No, Mr. Thornton, one person at a time. And right now, Mr. Anid is speaking.
I mean, I guess I would inquire whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you
Your
one
Honor.
chance to answer. What is a preliminary exam?
Court proceeding. Mr.
Okay,
Thornton
and
said
what-
that.
Okay, and what happens? That's a good answer. What happens at that court proceeding?
at a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether whether evidence is admissible to go into continual proceedings, whether the court has jurisdictions, a plethora of matters may be.
A plethora of matters. Oh, good Lord. He's better than I anticipated and still absolutely horrible.
Brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in one specific fashion.
Well, that's pretty, that's a pretty good answer. However,
That's generous.
at this point, given a review of
Which is number one.
history, the
Wrong.
court is going to sua sponte, suggest that a competency exam be ordered. Mr. Anid,
I
any
agree.
response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal or a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
Think of the public, Judge. Think of the public.
So, Mr. Anid, are you going to prepare a proposed order or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's I can if you want. Yes, I'll prepare an order.
All right, so at this time, Mr. Anid, comment on the preliminary exam?
No, I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or review hearing for when we do come back with a competency opinion.
Okay, so Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not.
Okay,
Mr. Thornton
so
has not
good
received
cause.
any instrument.
Okay, so, all right, two things then. First, I find good cause to waive the 21-day rule, and we will get
Objection, Your
a
Honor.
date. No, sir, just a minute, let me finish.
I'd like to
You
see without
can't, you
discussion.
don't, no, listen, I don't want to mute you, but I have to get through this. So,
He objects.
you have to have,
Waiving
you
the
have a
21 rule.
constitutional right to have knowledge about your case. And if you haven't received any discovery, we can't go forward until you receive it. So two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Sid. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. As soon as we get that date, then we'll go to the discovery issue. So next up, where we're going to adjourn this
Yeah.
case we're going to adjourn this case to a just lost that chat. To a probable cause conference at 8:30 a.m. on April 25th. And a preliminary exam date of 9 a.m. May 1st. Now, Mr. Anid, you wanted to be in a breakout room with Mr. Foreman. I'm guessing you want to discuss discovery. So,
And you, Judge.
with me, or you want to discuss me?
All three of us really quickly. That's okay.
Okay,
I would like,
do that? Okay. Just a moment, Mr. Thornton. We'll be back in just a moment, okay? Thank you.
And the attorneys will be right back in shortly.
All right, we are back on the record in the matter of People versus Latavis, Trashad Thornton. This is case 25-0203-FY. And for a moment, at Mr. Anid's request, the court, Mr. Foreman and Mr. Anid discussed standby counsel. So standby counsel is something with certain mechanical concerns. So for standby counsel, the court can't just appoint standby counsel. This is what we discussed in the breakout room. The court, or perhaps its funding unit, the city of East Lansing, would have to enter into a contract with the public defender's office. And if both sides agreed to that and a certain financial rate, then an attorney from the public defender's office would sit next to Mr. Thornton and be available to advise him during all proceedings. Back in the day, when I was on the court appointed list, a judge could just appoint someone and do it. That doesn't exist anymore because of the MIDC. So we discussed the mechanics of that. The court is going to make a formal discovery request on behalf of Mr. Thornton. So Mr. Thornton, you should receive at the jail, or if you post bond at the address we have on record, all of the materials that a defense attorney would receive that the prosecutor has. At this point, Mr. Anid would like to speak with Mr. Thornton and perhaps see if a plea deal is possible. So Mr. Thornton, you never have to accept a plea deal, but it's worth listening for two reasons. First, there may be something there that you can reach an agreement on. You have a constitutional right to have these charges heard in a trial. Sometimes you can make a bargain, something that is worth giving up your right for a trial, for instance, a lesser charge, a lighter sentence, or both. The other side is you kind of want to know what the prosecutor's thinking about the case. So, as a defense attorney, I always wanted to hear what the plea offer was. Even if my client was absolutely not going to take it, it gave me some insight into where the prosecutor was interested in going with the case. Again, you were never required to accept a plea bargain. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Anid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. All right. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you. Okay, let's see. There we go. All right, so we're going to wait until the sound is back on in the jail for Mr. Thornton, and then we'll resume.
Any objection, Mr. Miller?
I actually object to everything he's doing.
Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Anid, prosecutor, and Mr. Thornton, representing himself, have met in the breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Anid first, then Mr. Thornton, I'll ask you. So Mr. Anid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him. Do you?
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of what
that's a word salad. It's not making any soup. Can you any sense at all? Can you rephrase that for me, Mr. Thornton?
The salad that's not making soup?
So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing, and that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
And
okay.
I'll
yes,
chime in
Mr.
here.
Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our office to how we're going to go forward. I told Mr. Thornton, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as possible. And I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated. The only thing I have to ask is how do I provide discovery to Mr. Thornton?
I would guess that you could mail it to him or, yeah, I think.
I'll figure it out. I'll ask my office.
Communication through the jail.
Okay.
At his address through the jail, and it may have to be paper communication.
Okay. I'll do my due diligence today when I get to the office today, Your Honor.
Okay. And yeah, I don't have discovery demand in front of me, but that would include, of course, any exculpatory materials granted under Brady. That would include make a request for any body worn camera, any evidence you plan to introduce, any car video, any report that you have in your office other than what's protected under attorney-client privilege with a prosecutor or any counsel. Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates, Your Honor. New dates, new probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel. At every hearing, I'm obligated to tell you your right about counsel and to determine the parameters of that. All right, so we will see you back at 8:30 a.m., April 25th. That is all.
Thank you, Your Honor.
Thank you.
Take care.
Thank you.
Take care, Mr. Amid.
Thank you.
Well, there you have it. That was tons of fun. We had everything in there. We had soup, we had salad, we had ducks, we had shoulders, we had head, shoulders, knees, and toes. That guy was everywhere. The man with the voice. That guy. He was a lot of fun. That was good. Thank you, Alyssa, for sending that to me. As you can see, I had timestamps so I could get through it. I was kind of staying out of the way because I hadn't seen it, and I didn't know what he was gonna be up to. He knows nothing. I also liked when the attorney said, "Well, I'm past the competency issue," which I read as, all right, based on my conversations with him now, I think he's intentionally stupid as opposed to accidentally stupid. That should be a fun one. That should be a fun one going forward. Speaking of which, I don't know if I'll do that under my circumstances. I think I will. Maybe not live. Maybe. I don't know. Depends what gaps of time I have. But it appears to me that Natasha of Natasha and Bullwinkle fame, otherwise known as the fake attorney, is showing up. That's what Food Fairy tells me this afternoon, to be clown herself yet again. So if I get a chance, I might cover that one as well. Thank y'all for coming out. I appreciate it. I'll see y'all soon.